our last part of our conversation, let's start with what happens if somebody infringes my patent, or I, as a company, infringe somebody else's patent. What should I do as a startup?
Well, the first thing, relax. As a startup, usually you're not going to be a major target for somebody that is going after infringers. And likewise, if somebody is infringing your patent, assuming that they're a big enough player, there are actually people that will assist you in going after them at little or no upfront cost on your part. So the case where you're infringing somebody else's patent, often that's simply going to be a business discussion to figure out how you can mutually come to an understanding of how you can either change your product or acquire a license from them. Or there may be a rare scenario where it actually will have to go to litigation. And that can be challenging, but usually people are going to sue somebody because they think they're going to get a large amount of damages. As a startup company, usually you're not going to have enough financing for them to actually have anything to go after. So the cost of filing a patent lawsuit, which can easily be over $1 million, won't make business sense for somebody to go after you for even $100,000.
Mm-hmm. Okay. What about the trademarks and copyrights?
So with trademarks, again, often it's going to be a business discussion about how you can keep the separate either logos or brand names that you're using separate in the marketplace, so that one person doesn't feel that their goodwill is being taken by another person. One scenario is that companies will agree to stay out of different marketplaces, whether it's geographic marketplaces or it's product or service marketplaces. One company will agree to, just stay in the spa business. The other one will agree just to stay in the athletic gym business, and they can coexist with similar sounding names without consumers necessarily being confused. Mm-hmm. On the copyright side, copyright litigation, if you don't have a registered copyright, can actually be a fairly lengthy and complex process. But if you have taken the time to register your copyrights ahead of time, it can actually make copyright litigation some of the most straightforward, less expensive forms of intellectual property litigation. And it's actually one of the few times where startup companies need to be careful. So if they're going to be using images that they've found somewhere online, they want to make sure that they have the rights to use those images. And so actually going to one of the stock photo companies or stock image companies and paying for the license is actually a very small price to pay to make sure that they're compliant if they're going to be incorporating images into their product or website. Mm-hmm. Because if you have a registered copyright, you actually don't need to go through the damages investigation during the litigation. A judge can set a statutory fee for infringement, and particularly in a case where the other side has made a lot of copies, so they've had multiple copyright violations, by setting a set statutory fee, let's say it's $100, they've made 100,000 CDs of copyrighted software, that's $10 million that is instantly designated as the damages for those 100,000 copies. Mm-hmm. So it can actually be a very good tool for startup companies that are concerned about their product being copied, literally copied, as opposed to somebody recreating it in their own clean room environment, because that's not a copy, that's somebody else recreating it. Okay. And you can actually, that's one of the things about copyright, that you can actually have, as I mentioned before, two people that independently come up with the same thing, that's not a copyright violation. You actually have to have had somebody who has copied something for it to be a copyright violation.
What about if, because with the web it's very easy to take content and show it on your website, whether you syndicate it or copy it, what about those cases?
So I'm going to give you the lawyer's answer. It depends. You need to look at what the scenarios are. So there were a lot of interesting cases about deep linking to other people's content, and linking was generally not, just a bare link was not seen to be as a copyright infringement, but taking some deep linking to somewhere and then reframing it to give it a completely different context. So surrounding somebody else's newspaper with all your own ads while stripping out all of their ads was generally seen as a copyright violation.
Which brings me to the question with the latest news with all these big companies that are suing either other big companies, like between Microsoft, Google, to the patent, as well as the Lodsys case. If you can just give me a couple of sentences what your opinion is around these cases.
So as I mentioned before, one of the things that happens sometimes between larger companies is they each want to get into each other's marketplaces. And so patent lawsuits can be a tool, since often between larger companies, they both have so many patents that if they actually were to file lawsuits, it would be a mutually assured destruction. What can instead happen is that they'll come to some type of negotiated agreement where they both get the rights to each other's patents. And to a certain extent, it's this form of currency that is an alternate form of currency, and they just need to figure out who has a bigger, if you will, a chip stack at the poker table to then negotiate and see how they're going to play the game with each other. But when you're talking about Lodsys or other non-practicing entities, it's a slightly different scenario where oftentimes they'll have a stack of chips, but they don't have anything that they can be threatened with on the other side, since they're actually not making any products. And this creates a little bit of an imbalance in the situation. Normally it was balanced because it was two companies that are actually trying to compete in the marketplace, and one's patents can be used against the other and vice versa. In this case, with a non-practicing entity like Lodsys, it's tough to use patents against them. So what instead has happened is that people have attacked the patents, not the company. And so Google has asked for re-examination of some of their patents, and then a number of other companies have filed suit in federal court. At least 2 separate lawsuits have been filed to invalidate the patents because they're either not new, not useful, or obvious in light of what was in the prior art already. So Lodsys is interesting because it's created so much disruption among smaller players, which is very uncommon. But the bigger players have stepped in and are trying to protect the smaller players, particularly Apple, that's trying to intervene and say, you need to sue us first before you go after our developers.
Okay, I see those 2 frisbees, and you said that you're using those to explain how patents work. So can you show me how?
Sure. So as I mentioned, patents give you a negative right. And in 1967, when Wham-O patented this version of the frisbee, they were patenting a round plastic toy that had these laminar flow rings, so that when you throw the frisbee, it creates a low pressure zone and creates a more stable flight. Now, this was patented in 1967, the patent expired in 1984, but this company patented this product, again, round plastic toy with the laminar flow rings, in 2005. But what they did is they improved upon the design of this classic frisbee by adding a lightweight balanced lighting assembly. So there's an LED and some fiber optic fibers and a switch in the middle that turns it on. Now, even though they're using the same basic Frisbee design, the improvement itself was new, useful, and not obvious in the eyes of the patent office. And so they were able to get a patent on this combination of all of these elements. Mm-hmm. Now, if the Whammo patent was still valid, and it was still in force at this time, hadn't expired, then Whammo could actually go after Flashflight and say, you can't make this Frisbee, because all the elements that were in the claims of the Whammo patent are present here in the Flashflight patent. And interestingly, if Whammo now decides that they want to create an illuminated Frisbee using this design, then Flashflight could go after Whammo, even though Whammo had the underlying patent in the first place.
That's very interesting. Okay, Alan, I really appreciated your time, and thank you for this interesting information. I'm pretty sure a lot of people will be interested to see it. So, thank you once again.
That was my pleasure.